Good morning, everyone. I'd like to address you with a very warm welcome by the European IP Help Desk to today's webinar that is going to be about IP management in EU-funded project, but we're going to shed a special light on Marie Sklodowska-Curie Actions. And we are here with my colleague and the head of the helpline of the European IP Help Desk, Lea Montes. Thanks a lot, Lea, for coming and being with us. Morning. Before I leave you the word, however, just allow me to steal 7-8 minutes from today's technical knowledge in order to introduce to the participants the program that we are using, which is GoToWebinar, as well as a couple of administrative information regarding the European IP Help Desk. You might have already noticed that your microphone is muted, and this is because we expect to have a large amount of participants today, around 200. So imagine if everyone had the chance to produce even not willingly background noises, it would be a very hard situation for our speaker, which we definitely want to avoid in order to be able to learn and share information. Therefore, you're muted, but this does not mean that you're not allowed to ask questions. You're very welcome to do so, and you can type your questions in the window that you have on the right hand side of the screen. You have the part questions, and if you type your questions in there, I will gather them, and we will have a dedicated session at the end of the webinar of around 15 minutes, where we are going to, of course, do our best in order to answer to your questions. Now, the most frequently asked question that we always receive is, when are you going to receive today's slides and recording? That is going to happen this afternoon, at the latest tomorrow morning. We are going to elaborate the video, provide you with the link and the PDF slides of today's webinar, and also a couple of further useful information that might be potentially, we hope, useful for your day-to-day activities. Now, let's take a glance at the European IP Help Desk, what we are and what we do. The European IP Help Desk is a service initiative of the European Commission that has the main objective of helping mainly current and potential beneficiaries of EU-funded projects, researchers, and small and medium enterprises across the European Union. These are the main three target categories that we have for our services, but still the services you see on the right hand side of the screen are open to all physical and juridical persons who might have a problem with IP and IPR. The services you see are completely free of charge, but please remember that they are a first line support, meaning that we can provide you with a first help, helping you understanding what IP and IP rights are, but we are not going to substitute the job of, let's say, a patent attorney or a trademark attorney that is filing and typing and creating the actual patent application, trademark application, and so on and so forth. How can we help? Well, probably the key to access to our services is the website, which is ec.europa.eu/IP-helpdesk. And through the website, you can have access to a large amount of different services, which range from trainings, like, for example, today, which are online. Hopefully next year, we're going to be able to organize on-site trainings again. We also have publications. Publications are listed in a dedicated section of the website. They are downloadable. You can take them, use them, share them in your network without any form of limitation. We have ambassadors across the European Union that can help you, like getting in touch with the European IP Help Us, but also translating documents that we produce, which are always in English. We always also are present at events organized by the European Commission, awareness-raising events across the European Union. Finally, but probably most importantly, we have a helpline service which can answer to your specific questions, of course, regarding intellectual property and intellectual property rights within 3 working days and in the most possible understandable way. At the end of this short presentation, I will provide you also with the email account of the helpline, but through the website, you can actually send your questions if you want to, and contact the helpline in the dedicated part of our website. The territorial coverage of the European IP Help Desk services is, of course, the European Union plus the COSME-related countries, for example, the United Kingdom, as well as Israel, or Turkey, Switzerland, Norway, and so on and so forth. But if you'd like to receive more information regarding IP systems outside these territories, there's our siblings active in order to provide you with the very same services you saw before in the previous slides, but for different geographical areas like China, India, Southeast Asia, Africa, and Latin America as well. I said there are publications available online. This is a example of them: e-learning modules, guides, infographics, case studies, and so on and so forth. We are going to update them, and actually a new guide is coming up, which is your guide to IP in Horizon Europe. As soon as that is going to be available, you're going to know it, because I'll put it in the slides of the next upcoming webinar. Also, we have collaboration active in niche field, I would say. Some of them, like the CPVO, Community Plant Variety Office, where we tackle the topic of plant variety protection. There's one last appointment coming up on the 6th of December. If you'd like to take part, you're very welcome to register. If you'd like to watch one of the previous webinars that have already taken place, for example, you missed it, don't worry, you can ask us an email, ask access to the webinar with an email to us, and we will provide you access, and you will be able to watch the webinar at any moment. Also, you can check out our e-learning page, and also you'll have it in the follow-up email if you'd like to watch one of these webinars that have taken place. Also, we are active in our collaboration with the European Patent Office. And tomorrow, actually, there's going to be the last appointment for the session patent protection for EU funding beneficiaries. So if you would like to see how it works in different fields regarding patent and patent protection, you can very readily either follow the webinar tomorrow if you're interested in biotechnology, or check out in our e-learn or ask us to have access to one of the previous webinars you can see in here. I mentioned the ambassador. If some of them are connected today, I'd like to address them with a very big thank you for the work that they are doing together with us. They are professionals in the field of intellectual property rights that, however, are also part of the Enterprise Europe network. Therefore, they are a mix of knowledge and commercial capability. They can enhance, so to say, your intellectual property capacities, as well as finding potentially new cooperators across the European Union. So they are a very, very cornerstone of the European IP Help Desk and an important column of our activities. Furthermore, a couple of further information regarding learning opportunities. There's the main European agency on intellectual property rights, which is the EU WIPO, offering information on its learning portal, together with third parties and important, anyway, institutions like WIPO, number 4 WIPO Academy, or the European Patent Office. You can see it at number 11. These are the theoretical information that these agencies provide and institutions provide to the whoever user might be interested. If you would like, however, to have more hands-on information regarding intellectual property and intellectual property rights, there are other examples of that. One of these examples is the Horizon IP Scan. So if, for example, you are a small and medium enterprise and you are part of a Horizon Europe project that has started from less than 6 months, so you are in the beginning of the project or in the preparatory phases of the projects, you can be eligible to receive the counseling of a dedicated expert that is going to spend together with you a few hours through a pre-interview, a desk study where the expert is going to prepare himself, a main interview, and also you will receive later a PDF with the reporting of the case, and then you can discuss this PDF once again with a debriefing. And so this is a free of charge service offered by the European Commission to companies that are engaged in a collaborative research project or collaborative activities with companies across the European Union. You can check out our website, the website horizon-ipscan.eu, to see whether you are eligible. You can also make a request for receive the services, and a dedicated team is going to evaluate your request and communicate to you whether you're eligible or not. Again, I would like to mention the services and the website again of the European IP Help Desk, ac.europa.eu/IP-helpdesk, the helpline account helpline@iprhelpdesk.eu, the training account training@iprhelpdesk.eu, and then we also have Twitter and LinkedIn accounts where you can communicate with us. And having said that, I think I've already taken enough time from today's presentation, so I'm going to leave the word to my colleague Lea Montes. Thank you very, very much once again, Lea, for being together with us. The floor is now yours.
I couldn't hear you anymore. There was a small sound issue. Okay, now I will show my screen. Should be okay. Can you confirm, Michela, that you can see it properly? Yes.
I see it and I hear you as well.
Perfect. Well, first of all, I will quit the video for the time of the presentation. Well, first of all, Michela, thank you very much for the introduction, as always, and to all of you who are here with us today. I think you are actually almost 200. Thank you very much for joining us and for taking part in this webinar on IP in EU-funded projects with focus on MSCA. My name is Lea, and today I will be the speaker for this presentation. So, well, this is what we're going to talk about today, IP in MSCA. And beforehand, because I know there might be some concerns on this topic, I would just like to clarify that we're going to tackle MSCA in general, meaning both under the Horizon 2020 framework and Horizon Europe. I know now most of you who are starting an MSCA project might be doing so under the Horizon Europe framework, of course. But I'm also aware that some participants today might be here because perhaps they just joined an organization that is currently managing ongoing MSCA funded under the previous framework. For this reason, I decided to keep references to both frameworks, H2020 and Horizon Europe. And as you will see, I have tried to provide references to both whenever I could, so that you can find the relevant provisions easily. This being said, just so you know, generally speaking, the IP rules are very similar in both programs. So this presentation actually applies to both cases without any problem. As Michela said, at the end, in principle, we should be able, if everything is okay, to have a Q&A session. So don't hesitate to already prepare your questions if you have any at any point. Just a small final question, request, I would say. If you have a question in relation to something specific, I said, please put it in the question. Tell me which slides or which section this refers to, because if I see this is in 1 hour, I might not, understand what your question is about. So this way we can answer it better. So on to the presentation. This is what we're going to tackle today. First, let's say general introduction about the rules and agreements that apply in Marie Curie. I'm aware that this might be very basic for some of you who are already used to managing MSCA projects. However, as some others today might be managing them for the first time, I think it's important to start with the basics. Legal framework, contractual framework, and so forth, as well as the specific vocabulary. So we'll start there, and afterwards the core, I would say, of the presentation will be to show you the different aspects to keep in mind when it comes to IP management in the whole project cycle from beginning to end. In principle, we'll see if we have time. I have included a few slides at the end with frequently asked questions in MSCA, things that we had received for years, so already in the previous framework, that are still relevant today because those are the most frequent concerns raised by inquiries at the helpline, for example, or training participants when it comes to MSCA. In any case, then, as I said, I will also, in principle, be able to answer your questions. So, well, let's get started. First of all, yeah, a few comments about the rules and agreements. This is for those of you who are new to this. Perhaps you just joined an organization, an EU project office or something like this, and you don't know much about this. So this is for you. Here I made two different slides, one for Horizon 2020 and one for Horizon Europe. So starting with IP rules in MSCA Horizon 2020. You can find them in different documents. The main document, and the one I would always recommend that you go back to in case of any doubts, in case you want to see. Imagine you're running a Horizon 2020 MSCA, you just got into the institution, you want to check the legal basis, the rules, you're wondering what are the IP rights and obligations. It's always good to go first to the legal basis, and this is the rules for participation. That's an EC regulation, basically, that contains all the rules with regard to participation in Horizon 2020, especially all the IP rules and obligations. So I would always start there actually. Then the equivalent to these rules for participation in contract form is the grant agreement. So this is in case you have submitted a successful MSCA proposal. The proposal is getting funded. In that case, your organization and possible partners will have to sign the grant agreement with the European Commission or the Research Executive Agency. And in that case, well, you will have then a contract that will govern the entire project. And the same IP rules and obligations as the ones in the legal basis, of course, will be reflected in contractual clauses, contract form, in the grant agreement. So as you may know, you have different grant agreements for Marie Curie IF, ITN, RISE, and COFUND in H 2020. And there's also very useful guidance that is provided by the Commission for H 2020 in general. And all of this can be found in the annotated model grant agreement. You have all the links here. So this is, well, the main place where you can find all the IP rules as well as the guidance from the Commission directly. Now, sometimes it's also possible that a specific work program contains specific rule. In that case, it's always, for that reason, it's always recommended to double check the work program if you start working on a MSCA. And finally, there has been the Horizon 2020 online manual that was also a source of information. I have to say actually that for this one, there was an IP section that was for as long as I've been giving this presentation, that was always a work in progress. And at the end, they just ended up never really developing the IP section and just directing users to us. However, the online manual is very useful for other topics, also linked to, well, unrelated to IP, linked to eligible costs, for example, to the overall management of the project, and also linked to open science, dissemination, exploitation. So it's really a useful resource, although you will not necessarily find a lot on IP law directly. So how to find these documents? You just go to the EC Funding and Tenders portal in the Horizon 2020 section. And now for Horizon Europe. So as you can see, it's a bit the same structure. If now you are about to start or interested in submitting a proposal for MSCA in Horizon Europe, and you want to check the rules, you don't know exactly what you would agree to, how this would work. Once again, I recommend first getting to the legal basis. So these are the new regulations, this time for Horizon Europe. And once again, in that document, it's exactly the same. You will get all the IP clauses, rights, and obligations. And similarly, there will also be grant agreements that will be signed, will be the contract that as a beneficiary you sign if your proposal is successful. Here, there's a small specificity in Horizon Europe is that for MSCA, the grant agreements are the one for unit grants. So they are not, the applicable model grant agreement is not the global one applicable to most actions. is the one for unit grants. I put a link here, and again, it's applicable to the different types of Marie Curie, the doctoral networks, the staff exchange, PF, co-fund, etc. Once again, you have very useful guidance provided by the EC in the form of the annotated model grant agreement, knowing, however, that to the best of my knowledge, I don't think that there is specific guidance on Marie Curie specifically, but there's a lot of guidance on IP management in Horizon, which will apply to your Marie Curie project as well, especially when it comes to dissemination, to access rights, to ownership, and especially to open science. So I would really, really recommend having a look. Once again, I would recommend having a, let's say, double checking the work program before you start, just to make sure that no specific provisions apply to your specific call. That's always better to check. If there are specific IP rules and IP provisions, they will be in the work program. So it's always better to have a quick look to discard this option. And finally, there's the online manual for Horizon Europe, where once again you can have a lot of useful guidance on issues like dissemination, ethics, finance, open science. You can find them all on the EC funding and tenders portal once again. Now, this is another, let's say, entry-level slide, just to summarize a little bit the contractual framework that will apply to you as a beneficiary if you decide to enter an MSCA project. As mentioned, the first one, the main contract, framework contract, will be the grant agreement. This is the one that will be signed between the EC or RIA and the beneficiaries. And it's very important to remember that actually this document cannot be contracted by any other agreements. So whatever you sign after this one has to comply with the grant agreement. If there's, well, a discrepancy between the two, the grant agreement will prevail anyway. The second thing that you will have to sign if this is a multi-beneficiary action is the consortium agreement. So this is an agreement that is to be signed exclusively among the beneficiaries. Although I know that sometimes some consortia prefer also to involve the partner, well, the associated partners in that document. But in principle, this is for the beneficiaries. And here you have quite a few models that are available. It's important to know that the Commission does not release any official template of consortium agreement. So if you look for one and you don't find one, it's normal because there isn't one. However, there are models that you can use because they are renowned ones published by renowned organizations. For Horizon 2020 MSCA, there were two very useful templates, the LERO model and the BAC models. You have the links here. And then you had also the main ones for Horizon 2020, DESCA, UCAR, MCART. Now, as far as I know, and please do not hesitate to let me know if there's a model template that I'm not aware of. This is possible. Now, as far as I know, there's only DESCA for Horizon Europe. There's nothing so far specifically designed for Marie Curie, which means that you can use the DESCA one for Horizon Europe and adapt it to the needs of Marie Curie. Know that, for example, the previous one, the LERO one for H2020 MSCA was, if I remember correctly, based on DESCA, the previous one. So I would perhaps suggest having a look at the new DESCA for Horizon Europe, at the old LERO, and perhaps you can actually mix them a bit to get ideas how to tailor DESCA for MSCA. But please, if anyone is aware of specific MSCA templates, please let us know. That would be good news. And then, of course, still talking about different types of agreements you may need in your MSCA project, there is a possibility that you might need to conclude partnership agreements. Those are the, let's say, bilateral contracts signed between one beneficiary and its partner organization or associated partner in Horizon Europe. Once again, some people sometimes prefer to involve associated partners directly in the consortium agreement, but in principle, the way to involve these entities, for example, I don't know, a US entity that will be just part of the consortium to provide secondment opportunities, for example, that would typically be an entity that in principle should be involved by signing like a partnership agreement just with this entity, not including it in the CA. Once again, as far as I know, I haven't seen so far any template of partnership agreement developed for MSCA Horizon Europe specifically. The one I used to recommend before, and that you can still check and adapt to Horizon Europe, was the one from the German research support organization COVI. They had created a model partnership agreement some years ago for MSCA ITN. But this was a good document that complies with the grant agreement, and I think this can still be used as a basis or as an inspiration for your own templates. Finally, of course, there might be the research purpose agreement, which is the agreement that the institution signs with the MSCA fellow, and if needed, always confidentiality agreements and NDAs. Especially, this is especially relevant at the proposal stage. We'll get back to this in a minute. A very quick spin on the specific vocabulary applicable in Horizon Europe, actually in general, Horizon 2020, but also in Marie Curie. This is again part of the Horizon basics for those of you today who are a bit new to this. These are the key terms in Horizon projects: background, results, exploitation, dissemination, and access rights. And I will get back to them in the course of the presentation, but I just wanted to define them a little bit so that we are all on the same page today. So doing that, first of all, background. Background is basically all the know-how, all the input that you might, as a beneficiary, that you might bring into a project. So this is basically the basis, the reason why you were involved in a project in the first place. So this input can actually be tangible or it can be intangible. So that can be a machine, it can be data, know-how, information, and this is something that has to be held by the beneficiaries before signing the grant agreement, and something that will be needed in the course of the action to implement the action, to exploit the results. So this can be IP rights, definitely copyright, a patent, especially trade secret, for example, might be actually part of background, but background can be many other things, not just IP, but as I said, data and protected information, etc. Know-how. Here, perhaps anticipating already a couple of questions, it's very important to remind you that when you take part in Horizon projects, this does not have any influence on the ownership of your background. It happens sometimes at the helpline that we receive questions from people who are new at this, who are involved in a Horizon project, MSCA or other, for the first time. And they tell us, yeah, I'm interested in that. This is a good opportunity for us. However, we are afraid that we might lose our IP or that we have to share it. No, it doesn't work like this. Whatever you bring as background into a Horizon project will not, you will not lose ownership of it. This will remain yours. However, of course, you might have to give access in the form of licenses to the other partners. I'll get back to this in a second. And well, on the other hand, you have the results. The results, I think this is a rather transparent term. This refers to all the outputs of the action. Again, this could be IPR protected outputs, could be copyrighted work, publication, especially in Marie Curie, could be a patent, could be something that's protectable by trade secret, could even be a trademark if this is something that, if reaching the end of your project, you decide to trademark a logo, for example, for future exploitation purposes. But I mean, it's also much wider than that. All the deliverables of your project will be considered as results, the publications and the general know-how. Here, again, anticipating another frequent question, people who don't know the Horizon framework will sometimes ask what happens to what we generate. We are interested in taking part of in this, but because the EC is funding this, does it mean that the EU will own the results? The answer is no. In Horizon frameworks, including MSCA, the rule is that each beneficiary owns the results that it generates. The Commission, in principle, will never actually own the results. So that's something to remember. I was telling you earlier that when it comes to the background, for example, your pre-existing knowledge, it remains yours. So the fact that you introduce it to a project will not change that, but you might need to give access. This is the term access rights that is defined here. Access rights are basically the cornerstone of collaborative projects, such as some MSCA multi-beneficiary, for example. The idea behind access rights is basically the following. You have several partners who are getting together because they have specific skills that are complementary, because together they can actually work towards a common scientific goal. But for this, they might need to exchange know-how. They might need to exchange to give each other access to what they have in order to make sure that the project is going forward. And in order to make sure that this is happening and make sure that no one will change his mind and say after 2 months in the project, yeah, no, actually I'm not giving access to that. The Commission for many years now, or also in previous framework programs, has implemented this obligation of access rights. It's a right and an obligation at the same time. As a beneficiary, you have the right to request access to the other beneficiaries' results and background if you need access to them to perform your tasks, to exploit your results. But it's also an obligation for you, meaning that if other beneficiaries request access to your IP, to your background, to your results, then you have in principle an obligation to give access. This means in effect to give a license, nothing more. It's not about sharing ownership. It's not about open licensing or public domain, whatever. It's just about licensing your IP or your basically your assets for the time necessary for the project implementation or exploitation. That's it. And finally, here on this slide, you have 2 key terms, exploitation and dissemination, which are 2 of the main obligations applying in Horizon Europe and 2020, including MSCA. Why? Both of them come from the same idea, that these projects are EU funded, meaning that as a beneficiary, you will get you will get some of or all of your work funded by the EC. By the EU, and as a result, let's say the EU wants you to make sure that those results are being used and are being brought out to the community. So that's the exploitation obligation, which basically means that you have an obligation as beneficiary to use your own results after the end of the project and for a duration of 4 years. The Commission doesn't tell you how to use them. We'll get back to this later in the presentation. Here you have flexibility. Doesn't mean that you have to use them commercially. For example, it can be okay for you to use them in further research project to continue working on them. But you have to remember that in MSCA, as in other Horizon projects, you have this obligation to exploit the results that you create. Dissemination is the same idea, except that it's about basically disclosing the research results to the community, to the public as a whole, but especially to the scientific community that could actually benefit from it and take up those results and do something more with them. So that could be publishing the results on the website, in, of course, scientific articles, research papers, conferences, etc. I'll get back to this later, but here it's very important to know that since already Horizon 2020 and now even stronger in Horizon Europe, there are specific dissemination obligations that come with this type of funding, especially relevant for MSCA when it comes to scientific publications. So in particular, there's an obligation to release the publications in open access. And now this is new in Horizon Europe under specific Creative Commons licenses. So that's something to keep in mind as well. And again, the idea is to make sure that the community as a whole can learn from your results and perhaps take them up, and that it creates basically a virtuous circle. So this is, I think this is it for the introduction. Thank you for your patience. And now we get to the core of this presentation, which is basically how IP can be managed in the project lifecycle for an MSCA action. And especially what I will try to show you during this presentation is that IP is relevant literally at every single step of the way. What happens sometimes, what we see, for example, at the helpline, is that sometimes IP tends to be seen as a formality, like something a bit administrative that, okay, we have to agree on in the consortium agreement at the beginning, and then we will not think about it again until perhaps the end of the project when we have to exploit results. That's a mistake, because if you do that, meaning that you don't really keep an eye on IP during the project, meaning that you don't really manage it. Yeah, you sign 3 clauses in your CA, you forget about it, then you might actually have issues related to IP management that might block you at the time of properly implementing the project, and especially at the time of properly exploiting the results. So what I will try to show you here is, let's say, simple good practices that if you implement them will help you reach basically the end of the project and the exploitation stage in a way that is a bit seamless. Hopefully that will avoid blockages when it comes to intellectual property rights. So I will start with a very general slide, something that sometimes also we receive as a question. Sometimes we will receive questions that are very general in nature, telling us, for example, yeah, I'm going to take part in an MSCA Marie Curie, but I don't know what the Commission expects in terms of IP. And here, well, usually what we reply at the helpline team is something that can be seen as frustrating by our inquirers, but it's, let's say it's a lawyer's reply, which is, it depends. Because it's true that it depends. There is no general expectation. It will really depend on the specific program. It will depend on the applicability of the results, of the technology readiness level, of course. You won't have the same expectations in terms of exploitation for results with very low tier L, high tier L, etc. Depends also on the participation in the consortium. Is this a majority of SMEs, industry, academic institutions, the size of the consortium, the stage of the proposal? Basically, there are many parameters. So unfortunately, it's impossible to give you, let's say, a one-off template telling you this is exactly what you have to do in terms of your IP management. It depends on the project, and especially this is always what I end up saying, is that it depends on what you want. You have a lot of freedom in Horizon Europe, in MSCA, as a beneficiary, as a results owner. Of course, you have some rights and obligations that I will get back to, but within this framework, you are really free to exploit your results in a variety of ways. So basically, when it comes to IP management, you have to ask yourself, what do you want to do? What do you want to achieve? What will you need in terms of third-party rights? Who do you want to involve in exploitation? And basically tailor your IP management strategy from there. However, and this is why this presentation exists, there are still a set of good practices that we will present to you today that are relevant, I would say, regardless of the scope, regardless of the type of project, and regardless even of your of your goals. Those are just general good practices that you can implement in your MSCA action. So the first recommendation would be that IP is relevant already before the project is starting, of course. Why? Because as you will probably know, every project starts with an idea, meaning that you might see, well, as a researcher, or perhaps as head of a department, or you might see basically a call for proposals from the Commission for MSCA in a specific area for a specific topic. And here you might talk to your colleagues, you might identify perhaps researchers that are interested. As a researcher, you might think, okay, this actually fits my research area, and I could actually think of submitting a proposal there. And of course, you will have to develop a specific idea, showing the Commission what could get funded. So here it's very important to start with the beginning and define the state of the art. So here the question is, was this already done? Is this new, what you want to be doing? Is this something that already exists? Is this something that other research projects are already tackling? This is especially, of course, relevant for, let's say, highly innovative projects, projects where perhaps patents might be involved, etc. Basically, it's very important for us to check the patent databases, the patent information, the documentation, and more generally, check online, check the state of the art, what's already been done, what's already existing in this field. Why? Well, simply because, well, on the one hand, you will want to submit a proposal that is innovative. So this is for you to show that you are bringing added value. But this is also to make sure that you do not, let's say, step over the territory of someone else's patented information, for example. That could be a problem later during the exploitation stage. So basically, it's very important to check from the beginning what is the state of the art, what is the landscape when it comes to IP, whether there are already rights, whether there are projects that could be competing that you want to avoid, whether there are rights that you know you have to basically stay away from, because yeah, some third parties already have some exclusive rights in certain areas and you don't want to get in there in order to protect future exploitation possibilities. So that's the first step. The second step is that I mentioned already earlier, that you will have probably, as a beneficiary, you will have to bring background into the project. That means that you might have to actually put your know-how on the table, possibly some IP rights, possibly also some tangible assets, and basically, if needed, if relevant, to share it with the other beneficiaries. So here, it's always relevant before you join collaborative projects to assess a little bit what you have, to assess a little bit what you will be bringing, and to see whether any of it could be protected beforehand. Of course, there will be a contractual framework in place. You will take part in a project with different partners. There will be a grant agreement, a consortium agreement. There will be specific rules, but still, it's always safer to protect whatever you can protect before actually, well, disclosing it to third parties. Especially, and here for me, this third bullet point is the most important, is to protect all the information linked to the idea. It's very, very, very important, and I will not repeat it enough, to always use NDAs, non-disclosure agreements, or confidentiality agreements. It's the same when you're contacting potential partners. So imagine you saw a call for proposals, perhaps as part of an EU research office or something like this. You think, okay, you will get in touch with, you know, this and that partner that you already know from before, perhaps this or that researcher that would be interested in, you know, jumping in this project and submitting the proposal with you. Sometimes it might be tempting to skip the formalities, especially if you are getting in touch with third parties that you know, with whom you have already worked. Here, I would really like to really stress the good practice is always at the stage of working on a proposal, exchanging the initial ideas for the proposal, always conclude a non-disclosure agreement. Why? Because ideas like a research idea, a proposal idea, a project idea can never be protected by IP, never. You cannot just have an idea about the project, think, okay, yeah, I will submit this idea to the commission and see, you know, if it gets funded, but I believe in it, it's a good one. And then think this is your IP, and this is a common misconception that we see way too often, unfortunately, still at the helpline. What we see sometimes, several times a year, is that we have people contacting us and telling us, well, I had this great idea for a project, for an MSCA, for example, or different type of project, and I disclosed it to this and that partner, and you know, we started the negotiations for the proposal, and finally there was this agreement, and one of them dropped out, and then we realized that they submitted another proposal in our backs based on exactly the same idea. And of course, this is really decreasing the chances, because now you have two competing proposals on the exact same topic. And what people usually tell us at this point is, usually the title of the email is someone stole our project idea, or, you know, like infringement of our IP right on the project. And unfortunately, at that point, we have to explain that there is no IP right on the project. There is no IP on the project idea. So, well, of course, someone basically dropping out of negotiations, taking the idea and submitting the same project in your back, for sure might raise some ethical questions, but this is not an IP infringement issue because there is no IP here. It's just ideas being discussed. There is no IPR. So the bottom line is that the only way to prevent this from happening is to protect those ideas contractually by an NDA, non-disclosure agreement. If you do that, then the partners you're talking to for the project proposal preparations will be bound to you contractually, not to disclose the ideas further, not to reuse the ideas further. You can have a clause in the NDA that says clearly no one is allowed to reuse this idea for a competing proposal this year, next year, whatever. This is the only way to protect the project idea and basically avoid the problem that I just described. So this is my main recommendation here, always use NDAs. And well, the last point, still before the project starts, is to always also have a look at third parties' IPR, and especially here I'm thinking of trademarks. Here, the case is, as let's say, the following: always make sure that you choose a project acronym that is not similar or identical to a trademark that is registered in the same field. Why? Because it might happen, unfortunately, that you think it's okay, it's just a research project, you will not be carrying out any commercial activities, so you don't pay any attention to your acronym. You find an acronym that is catchy, you use it, and after 1 or 2 years, you receive a cease and desist letter from well, a company that has the same name. They have this as a registered trademark, so they have actual IPR on your project name. And well, it turns out that unfortunately, it might happen that they have registered their trademark for products or services that are very close to what you are actually doing in your project in the same field. So here it's a really gray area, because on the one hand, you might say, yeah, I'm not infringing your trademark because I'm just using this as a project name, nothing more. But at the same time, first they might sue you anyway, or well, sue you, or at least send you letters. You might have to resort to lawyers to reply to this correspondence. This will incur time, cost, stress. And especially before and especially after, if you plan to exploit the project results at some point, especially commercially, then you won't be able to do this under the same name, because then commercial exploitation under the same name for similar products, for example, would actually be infringing that person's trademark. So for this reason, I always recommend to always have a look at well, online or trademark databases to make sure that your basically your acronym is not too close to an existing trademark in the same field. You can do that if you are part of a university. You can do this quite easily, I think, with your legal department. Ask them to help you check that. So that's before the project starts. At the same time, it's very important at this point already to start thinking about exploitation and dissemination. Here, let's say, I wouldn't say this is a good practice, because this is actually compulsory. So this is something you will have to do, whether you think about it or not, because in the proposal, you will be asked to describe a little bit the IP and exploitation, well, ideas and strategies that you have in terms of impact and implementation of the project. So it's important to remember that actually your project proposal will be assessed in 3 terms: on excellence, on impact, on implementation, and IP will be relevant, especially for impact. This is where you will talk about exploitation, dissemination, how you will actually take your results further, how you will be able to use them. And well, implementation is how basically you will be able to which kind of measures you will take to ensure proper management of the action, and that could include IP management measures. So what is happening is basically in the proposal, you will have to submit well, what was in Horizon 2020 a draft plan for exploitation and dissemination of results. Now it's dissemination exploitation plan. In Horizon Europe MSCA, in principle, you have the Commission asks you to basically submit an outline of this plan with the proposal, and then if the proposal is successful, you will have to submit a full-fledged plan for dissemination and exploitation within 6 months, usually, into the project. So this will come really quick. For this reason, it's very important to have a clear idea already at the proposal stage of basic dissemination and exploitation ideas, strategies, where you want to take the projects. So that's the first point. As I was mentioning, of course, your proposal will be assessed in terms of implementation. So that means that if you identify relevant bodies, relevant competencies in the consortium, for example, an IP manager, IP management board, if relevant, perhaps in your project it's not relevant, but in larger projects, very innovative, it could be useful. Then this is something that you can mention already at the proposal stage to see, well, for the evaluators to see that you are taking, let's say, IP seriously, and that you have put structures into place to actually manage and handle this issue properly. And of course, already in the proposal, you can include relevant activities and deliverables that are related to IP. So there's the dissemination exploitation plan that is in any case compulsory, but depending on the case, depending on your needs, you might include milestones related to future market analysis, business plans, risk analysis, FTO, specific contracts or agreements being concluded at specific later stages, etc. So you can really already use the proposal as a way to plan already a bit what's going to happen in your project in terms of IP and relevant milestones, competencies, etc. Here I will take a second to advise the MSCA fellows or future fellows who might be listening in today. It happens sometimes that MSCA researchers or researchers working on a proposal contact us and tell us, yeah, what do I put in this? What do I put in that? I'm submitting this section. I'm not sure what to put on exploitation section. Here, my main recommendation is please do not draft this part alone. You might be even the main scientist drafting the proposal. This might be your project or your baby, let's say, but at the same time, you will be submitting this with your host institution. And because in principle, by default, your institution might be actually the one owning the results, the one having to exploit them. This is, unless you reach different agreements with them, is very important at this stage that you don't draft this alone, because they will be in charge most probably of exploitation, of dissemination, of management of the IP even. So it's very important that you reach out to your legal department, EU projects department, technology transfer department, depending on the case, and you make sure that you draft something together that fits your vision as researcher, but that fits your organization's IP policy and exploitation policies. Make sure basically you get support on this section. Well, the exploitation and dissemination plan, I already talked a little bit about it. So in a nutshell, it's something that you will have to think about at the early stages. I explained to you why, because actually your proposal is going to be assessed and, let's say, graded, evaluated on this basis, among other things, but this will contribute to you getting points. So if you have already specific impactful exploitation dissemination measures in place from the beginning in your proposal, this will help you ensure that you get enough points perhaps to get the funding. So what do you have to do in that? You basically have to define the expected results and draft a strategy for their exploitation and dissemination. Here you have a very quick outline of the different things that might be included in there. So usually what I do is that I tend to recommend people using, for example, a table of expected results. Name the results, describe them, very important, mention the planned or the envisioned ownership status. This is important because basically exploitation derives from ownership. The one exploiting the results in the end is the one that owns them, or the one, the owner is the one going to take the decisions to license, to transfer, etc. So I would always start by describing the results, describing who in principle in the consortium will own them, and then, well, which sectors these could be applied in, the exploitation routes intended, what would be necessary to get there, and also the IP protection measures that will be relevant, if any. Of course, you should also list all the means through which this knowledge will be brought to the public. So already list some conferences, envision publications, well, any kind of dissemination measures that you can think of. And of course, the purpose of all this, especially in MSCA, is to show, well, impact in terms of marketability if this is the focus of your action, but otherwise in terms of research investment. Basically in MSCA, it's important for the proposal to show the impacts that this could have on the researcher's career. So this is the exploitation dissemination plan in a nutshell. Here I would recommend to know more about these topics that are quite complex. You can see a lot of examples, good practices about all of these issues, how to tackle them in the proposal in 2 brochures that my colleagues from the help desk have created. one for H2020 called Making the Most of Your H2020 Project, and the same for Horizon Europe called Successful Valorization of Knowledge and Research Results in Horizon Europe. In those ones, you will see a lot of things about exploitation, dissemination, valorization of research results, and this can be of help to you at the time of drafting your proposal. So imagine you have done all that so far. You have checked all the third-party rights, you have protected what could be protected, you have concluded NDAs, and you have submitted the proposal with good measures for impact, for exploitation, dissemination. You have done all that so far. So as you can see, this was quite, until now, a quite IP-intensive activity where you had to consider lots of different aspects. So imagine then your proposal is successful and you get the funding. Here what will happen is that in principle you will have a couple of months, I think 3 months for grant preparation, and then your institution is going to sign the grant agreement with the Commission or RIA. And after this, well, the project is going to start. If you have different project partners, you will have to sign a consortium agreement. I will not get into this specifically today. However, know that we have another webinar focused specifically on consortium agreements. It's something that I also give regularly, and you can check it in our e-learning section. So all the tips about how to tailor your consortium agreement, what you can include, what you can change. This is something, if you're interested in that, you can check the replay from a webinar we gave in October. It is online. So anyway, imagine that you have done all that. You have even concluded the consortium agreement, everything is fine, you start the project implementation. Here, it is the time where, unfortunately, well, in my experience, the problems happen. Why? I mean, the problem where I would say the mistake happens. In many cases, what happens is then, of course, then you get focused on the work. The researcher starts researching. The admin teams, the support teams will, have an eye on management, on the costs, on the meetings, etc. So basically, everyone, of course, and this is normal, is focused on getting the project going and getting the project working. What tends to happen in those phases, in the implementation phase, is that IP gets a bit forgotten, meaning that you have your consortium agreement, your proposal is somewhere or in a drawer, and especially the consortium agreement is signed and forgotten. I will give you an example perhaps to illustrate the issue that can happen with that. What happens to us, and unfortunately it happens several times a year as well, is that sometimes we receive the same questions from Horizon participants who tell us, hi, listen, we don't know how to deal with an issue. Now we are blocked in our project. What happens is that, we had this consortium agreement, and according to this, everyone owns what it generates. And now we are reaching the end of the project, and we have a dispute. We think that we own the specific result, but our partners think that they should have some ownership rights as well. So we don't know what to do. And the thing is, in those cases, we cannot really help. First, because we are not in the consortium, so actually we have no way, being external, we have no way of knowing who did what, but especially because it's too late. What we tell them in that case is that, no, the good practice would have been actually to basically keep an eye on the results as they were being generated throughout the project, and not to wait for this kind of issues to arise at the very end. So that's my, I would say that's the good practice here, is really to have, let's say, an active way of managing the research results and of securing them as they arise. Not to wait for the last minute, because imagine in 3 years, if, okay, you are reaching the exploitation stage, you as beneficiary number 1, you think that, okay, you have a green light and, you have freedom to exploit your results as you see fit. And then beneficiary number 2, your partner thinks, well, comes forward and tells you, no, we don't agree. We think we should be co-owners of this because we contributed in this or that way. So actually, we don't agree, and we claim perhaps 50% share. And yeah, we should sit down and talk about this. And this kind of issue does happen. And if it does happen, it will really delay your possibilities of exploiting the results, because you will be blocked until you find a solution. I'm not saying that tackling this earlier will magically solve everything. You might actually have the same issue with the same partner, but at least you will have it as the results arise, when everything is still fresh in the people's memories, when you still know exactly who did what, when people are here to actually testify what they contributed, what kind of efforts they took on this or that task, what was done, and then you can discuss things, and more importantly, you have time. You have time to do that, which means that you don't have like the time pressure of thinking, okay, we are reaching the end of the project, we have to exploit things now, and we are blocked. So it's always very, very, very important to have a clear strategy from the beginning for securing and managing new generated knowledge. For example, that could be the task for the IP manager, if there is one. In smaller projects, that could be a task for the project manager, to basically always keep an eye out on who owns what, who generated what, which new results were created. If there are key exploitable results, very important to make a roundtable to check who has ownership claims on that. It's better basically to see ownership issues or contradicting claims or something right now than in 3 years, where we will be all stuck and we won't know what to say. Also check which protection steps are taken, etc. So the key takeaway for me here is really do not wait for this until the end of the project, because then you might have some time issues. So I included examples below, some of which I already mentioned. For example, of course, appoint an IP manager, or yeah, again, it could be the project manager in some cases, basically someone in charge of keeping an eye for this, perhaps of maintaining a regular check at every consortium meeting or every 6 months, every year. You decide. This is up to you, but perhaps you can think of a regular frequency according to which the IP issues will be checked. Of course, it's very important to always make sure that the staff involved in the MSCA project keeps the work logs, the lab notes, whatever proofs of the work actually being carried out, because this will help at the time of solving potential ownership claims. So what I already said, to schedule regular checks on ownership claims. Something I would also recommend at this point, especially now in Horizon Europe, is to prepare a draft ROL, which is the results ownership list. Some of you might be familiar with this term already, ROL. This is something new in Horizon Europe, and it will also apply to MSCA. This is basically, it's an administrative requirement, let's say, so it's deliverable. This is something that now the Commission is requesting at the end of the project, I think, if I'm not mistaken, along with the final report. And basically, this is mandatory. Each project has to submit this role in order to then to unlock the final report, final payment. So what in it, it's basically a list of the key results of the project as well as who owns them. So again, it's the same. If you following the same logic, if you forget about this and you remember about this ownership list, at the very end, you might have some bad surprises. You might think that all along you thought everyone agreed on this result or that result, only to find out that actually no, different partners had different ownership claims. That's absolutely, I mean, this happens because people don't always have the same understanding of the ownership rules applying in Horizon. The main rule is actually saying, okay, each beneficiary owns what it generates. It seems clear, but it's actually a very vague rule that is open to interpretation. Imagine if I'm developing some code, some software in the framework of a project. I'm the developer, so in principle, my institution will own the software. Now, what happens if one of my colleagues from a different partner help me by just testing a bit the software? Did they contribute? Do they have claims to owning at least, I don't know, 20% of this software? I don't know. They might. So in that case, it's very important to discuss these issues really ahead of time. Well, still in terms of implementation, apart from this, which for me is the biggest point, of course, you have to keep an eye on the plan for exploitation and dissemination. Remember that this is not a static document. This is, in principle, a deliverable that you have to update regularly. So you have to update when you have new opportunities for exploitation, for dissemination. But also, it's possible that sometimes the initial plans you had for the use of your results, for the disseminations, it's possible that these plans change. And in that case, that has to be reflected in the PEDR. At the same time, and that's the last hint here, I would really recommend not falling asleep during this time, because again, it's tempting to think, okay, now the project is on track, we got the funding, we get to work. And of course, at this point, IP becomes a bit something, let's say, an issue that gets relegated in the background, because okay, you got the funding, everything is fine. But you have to keep in mind that while your project is running, the rest of the world keeps turning, meaning that there might be new external factors in a neighboring country, in a competing institution, on the other side of the world. There might be things happening elsewhere that might affect your possibility of delivering the results as planned, or of exploiting the results as planned. Think, for example, of a competing project in the US or somewhere, like a team that releases results before you do, for example. What does it mean? Does it mean that you have to change your research focus? Does it mean that you have to rethink certain things? Imagine that someone patents something that suddenly ends up blocking some of your planned exploitation activities. You have to be reactive. So basically, the question here is not whether something will happen, because it's highly possible that some changes will happen in the landscape surrounding you in your field. The question is just to make sure that you are agile enough and that you can react to these changes, and basically make sure that you adapt your exploitation plans and activities accordingly. Okay, that's the big slide result of text, but actually I will make it simpler. I already mentioned this quite a lot, but I think it bears stressing a bit more, because it is the main, in our experience, at least this is the main issue in Horizon Europe, especially in MSCA, is the question of ownership of results. There are traditionally a lot of questions about this in the framework of MSCA, because there are third parties involved. So, as mentioned already, it is very important in any project, especially in MSCA, to always clarify the ownership of results early. This is the first bullet point here, and the reminder to basically do what I already said. Keep track of the work done, monitor the creation of results, and the related ownership claims, because always keep in mind that you might think something and your partners may think differently. The second point is what I want to stress here. The fact that in MSCA, in principle, the specific, the rule applies as in the rest of Horizon Europe when it comes to ownership. The rule is that basically every beneficiary owns what it generates. You have to be careful here, but this means, and this is especially a message for the Marie Curie Fellows here today, this means that in many cases, this rule means that you as a researcher will not have specific rights on the results. In many countries, but this is not harmonized, that's the problem, is that this will depend on the law of the country where you are based, where your institution is. So you have to check this on a case-by-case basis with your own institution. If I'm not mistaken, I know that in some countries, for example in Sweden, it's actually the opposite, where by default researchers benefit from what's called the professor's privilege, meaning that they will in principle own the results that they create. But in most countries in Europe, it's not the case. So basically the default ownership rule that applies in Horizon Europe is in line with most IP legislations in most European countries, according to which in principle the staff does not have automatic rights to the results, the institution does. It's important to keep this in mind as a researcher, because it means that first you should check what your IP policy or what your contract says with your institution. And if you would like to have some rights and you see that you don't get them automatically, then it's possible, but then you should negotiate them. Know that it's possible, at least in the Horizon 2020, Horizon Europe, MSCA rules. It's always possible to change this ownership rule. So when the Commission says, okay, the beneficiaries will own what they generate, they also allow transfers of ownership and different types of arrangements. So this is not a rule that is set in stone. Important for you to remember. Different arrangements can be met, but you have to remember to basically address them with time and basically anticipate these issues. Perhaps the most common case in MSCA, this is what is written in pink here, is are the issues that sometimes arise with partner organizations or now associated partners. So typically, well, in our experience, this is the case we see most often. Typically, US universities that are involved in a project as associated partners, they will be providing secondment opportunities for the fellow, for example, and there are third parties in the project. So what might happen sometimes is that the project coordinator says, okay, there are third parties, they don't have any rights because they are third parties, but then the US university says, well, actually, we are okay to be involved in this MSCA, but we want some rights on the results. Or they will say, but whatever the fellow generates while they are at our place in the US will be our property. And then they will usually take out the invention disclosure forms, the IP policy documents. They will ask the fellow to sign this, and then it happened to us sometimes to be in touch with fellows being on secondment in the US telling us, what do I do with this? Can I sign this? And the answer is actually always, no, do not sign it. Talk to your host, talk to your home university, your European one. So this is a message to fellows here. If you are, let's say, caught in this ownership issue where basically for example, your US institution, as is commonly the case, is asking you to give away some rights, to sign some forms, allowing them to retain ownership of the IP, it's very, very likely that actually, as a researcher, you're not entitled to sign those documents. You should actually give those documents to your European institution and ask them to talk to the US one directly, because most likely they are the ones with the rights on the results, so they are the ones who should be able to negotiate. Going back to the US universities or the associated partners claims, it's, however, important to know that these claims can be legitimate. Imagine if the organization contributes to the fellow's work, if they provide infrastructure, etc. It's very possible that actually, I mean, it would be normal for them to perhaps own a part of the ownership, for example. This is possible. This is the main thing I want to say here, because there are misunderstandings. Sometimes beneficiaries will contact us and they will tell us, yeah, but the grant agreement says only the beneficiaries can own results, so basically we don't want them to own anything. It's not like that. The grant agreement says that. The grant agreement also allows different ownership arrangements. So it's possible for you to consider a situation where you would be sharing ownership with the partner organization, for example. But you have to basically anticipate this, see whether there are specific restrictions in your consortium agreement, in your grant agreement. Basically check that. And here I would really recommend that you check out the partnership agreement template that I mentioned earlier, the one from COVI for ITN in Horizon 2020. This is a good example of a partnership agreement that talks about IP in a way that is balanced and that is compatible with the grant agreement. Even with this general rule saying basically whatever the partner organization creates is for them, whatever we create together is jointly owned, whatever the fellow creates alone without any input from the partner will be owned by the EU institution. So you can check this out, but the bottom line is that it is frequent to have the associated partners claim at least joint ownership of the results. It's okay to agree on it in principle, but you have to basically to make sure you negotiate this ahead of time. If the institution, this partner is located outside of the EU, again, typically US, Australia, Japan, it might be that you have to talk to the Commission first to ask them in cases where you would transfer the whole ownership to them. because, as you might know, there are restrictions to transfers of ownership approach. So all of this to say, it's possible, but you have really to spend time on this and to anticipate, because you might need some time to negotiate these arrangements. Finally, in terms of ownership, I'm getting back to the, let's say, the general framework of Horizon MSCA. If you are involved in a collaborative MSCA, multi-beneficiary, then it's possible that some results will be developed by several partners jointly anyway. Here, remember that you have an obligation to conclude a joint ownership agreement. That is actually something that the grant agreement imposes. It says that whenever you will be developing results jointly, you will have the obligation to conclude this JOA. And here I included a link to you to a fact sheet that we have created on this topic. It's not a template as such, but it's a guidance document with a lot of example clauses and checklists. So this is something that you can do. So that is about ownership. As mentioned, it's very important to, let's say, keep a very clear stance on ownership from the start. It will make your life easier. Now about access rights. So you might be owning specific results. Again, as explained in the beginning, because some projects are collaborative in nature, you have to remember that you might have the obligation to share these results or your background. By sharing, I don't mean sharing ownership, I mean making those results or this background available to others to allow them to perform their tasks or to exploit their results. So this is the access right mechanism that I mentioned in the introduction. And here you have, let's say, an overview of the conditions of access rights as they are set forth in the grant agreement. They are the same in Horizon 2020 and Horizon Europe. The bottom line is that basically access to background for implementation purposes is usually for free, but you can agree differently before you sign the grant agreement. Access to results for implementation is usually for free. However, access rights to background or results for exploitation purposes doesn't have to be for free, meaning that if you want, imagine that someone asks, I don't know, a license to your patent, to your copyrighted work that they might need in the framework of their own exploitation activities. This is something that you don't have to give away for free, and therefore this could be also for you, let's say, an exploitation opportunity, commercialization opportunity. A specificity of MSCA when it comes to access rights is the last part of the table that you can see below, is the fact that there are specific access rights for MSCA researchers. This is of course because MSCA is about mobility. So if you have a researcher moving from beneficiary to beneficiary, the Commission wants to ensure that these researchers will have access to each beneficiary's background and results to perform their tasks. Only to perform the research tasks, however. Here it's very important to remember, if you are an MSCA fellow, that you will not get, in MSCA, you will not get specific automatic rights to use the results that you create. Again, unless you are in specific countries like Sweden. In principle, if your entity, if your institution owns the results that you create, you will not get an automatic right to exploit them. This is something that you can negotiate. This is something that you can check with your organization, but it's not something that is foreseen in the Horizon MSCA framework. That would be different, for example, with ERC projects, where the principal investigator gets a bit more rights on the results, and now with EIC, where the researcher in EIC gets a bit more rights when it comes to exploiting the results. In MSCA, you don't have that, so it doesn't mean that you can't exploit your own results as a researcher. It means you have to make sure you ask the related rights. So now imagine your project is on track and you are developing results, you have your IP manager or project manager checking them, everyone agrees. Just remember, and this is the object of the next few slides, just remember that you have three main obligations when it comes to your project results. You have the obligation to protect them, to exploit them, and to disseminate them. So when it comes to protection, it's important to remember that each participant has, so each beneficiary in fact, has to protect its results in an adequate manner. The Commission says that, especially when it comes to results that have a commercial potential, industrial potential, and the Commission says you have this obligation, of course, when protection is possible, reasonable, and justified. So it's not, let's say, a die-hard obligation to protect, it's an obligation to protect relevant results if possible. However, it's important here to stress that the Commission doesn't impose any kind of protection measure. And this is sometimes a common question that we have received in the past. Researchers telling us, yeah, we know that there's an obligation to protect, but I don't think I will be producing any kind of patentable output. My research is in, this or that field, social sciences. I will not produce any invention, for example, any patentable invention. What do I do? And here it's always worth remembering that this is not the point. The Commission doesn't force you to patent. The Commission just tells you make sure that each of your outputs is adequately protected depending on its nature. So as you can see here, you have different IPRs that apply to different types of outputs. If you have inventions, of course, you might consider patents for utility models. You might, however, also consider trade secrets. That's the last one on the list, confidentiality mechanisms. If you have distinguishing signs, for example, logos that you want to use in trade in the future, this is something you can register as trademarks. If you develop specific products with specific appearance, you might look into industrial designs, and especially relevant to MSCA if you are producing manuals, books, research paper, articles. This will be protected by copyright, and that is how you protect your results. So again, not an obligation to patent. And if in certain cases you have patentable outputs, you might also decide not to patent and justify that in fact you prefer to protect this or that by trade secret for this or that reason. So there is flexibility in this way. Then I already mentioned the obligation to exploit the results. This is an obligation that applies to all beneficiaries that received EU funding. And accordingly, basically, during 4 years after the end of the project, you meaning the beneficiary, will have to use the results to exploit them. Here again, it's important to remember that this is not an obligation to commercialize. In MSCA, there will be cases where this is academic research, there will be no commercialization. However, what the Commission wants is that those results, when created, are being put to use. This can be by using them in further research activities, so outside the action doors. For example, in a different research project after this one has ended. Could be, of course, developing, creating, marketing a product or a process or a service if this is something relevant in your field, or for example, using the results in standardization activities, once again, if this is relevant. Another thing to remember is that because sometimes we have entities telling us, yeah, we don't have exploitation capacity. It's okay, you don't have, nothing in the grant agreement forces you to exploit the results directly. Actually, the Commission tells you you can resort to direct exploitation, but also indirect exploitation. You can transfer ownership of the results, you can license them, you can grant even exclusive licenses, can be commercial, non-commercial, etc. So here it's really, really up to you. Of course, remember that whatever plans for exploitation you might have to be in line with what you already planned, what you already described in the dissemination and exploitation plan. And then this plan should be updated as you develop those activities. I already mentioned a bit the rules for exploitation. As I said, the Commission doesn't force anything here, so you can use them in further research, develop product services. Might be relevant, especially in MSCA, where in some cases you might, at the end of the project, realize that you have the opportunity to start spin-off activities, for example, etc., etc. As you can see here, the first point and the comment in pink, this is something I already mentioned. Sometimes MSCA fellows forget that as such, they might not own the results that they have created in the framework of the project. It depends on the country, on the contracts. So they forget that, and so they think that at the end of the project, they are free to continue the research, take the results somewhere else, for example, to a new institution and continue working on them. It's possible, but you have to remember that this is not automatic, because in most cases, your home institution will retain the rights. So this is something that you have to negotiate. For example, an assignment or license with your home institution. Keep in mind that in many cases, it's not something that can be done automatically, although these are your results, and you consider them as such. The small frame that you see below is about the result platform. You might know this tool already. This was implemented under Horizon 2020 already, but now it's being really rolled out more, meaning that in Horizon Europe, including MSCA, there is now for exploitable results, there's basically an obligation after 1 year to use the Horizon result platform to find some partners and some exploitation opportunities if you haven't been able to find your own exploitation routes after 1 year. So basically, this is not the Commission punishing or anything. It's just the Commission telling you, okay, you are free to exploit your results the way you want. But if you don't manage to, because perhaps you don't have the reach to find interesting parties, after 1 year without any exploitation from your side, we will ask you to put your results out to promote them on the Horizon Results platform. It's just a way of potentially finding partners that could help you take them up. And finally, the last main obligation I wanted to mention today is the obligation to disseminate results. Dissemination, as already explained, is the way in which EU-funded results are brought to the attention of the public, and especially are basically divulged to the scientific community. You have an obligation in MSCA to disseminate the results swiftly by any appropriate means. We know that in MSCA, in many cases, this will be by way of scientific publications, journal articles. Two things here to remember. If there is a conflict that can happen sometimes between dissemination and protection, imagine you want to disseminate, you want to publish right away, but some of your partners whose information, whose results might be disclosed in that, want to patent first. In that case, the Commission always says that no dissemination of results may take place before appropriate protection is sought. So the right order is basically to first think about the protection of results, take the related decisions, and then once you have secured the protection, to actually make sure that you disseminate. In principle, you should remember also that there's an obligation to acknowledge EU funding in any dissemination activity arising from Horizon MSCA. Basically, there's a statement you can find in the grant agreement that you have to reuse as such, explaining that this work received funding from the Union. And basically, well, I would say more importantly, remember that for scientific publications, there is this open access requirement. If there is data underlying the publication, then the related data has to be also made available in open data. That is the main obligation. There can be some exceptions. Basically, the main principle when it comes to open science by the Commission is something like as open as possible and as closed as necessary, meaning that you should make the publication available for sure, the data, if possible, as well. Also keep in mind that in Horizon Europe, you might have some possible open science applications for different types of output. So you have to check the call to see whether these things apply. Here, I would like to take this opportunity to mention a very useful service that is also EU-funded called openair.eu. You have the link here. This is for all, this is a EU-funded support service. They have a help desk, they have FAQs, publications, that is competent for any questions and doubts in relation to open access, open data, open science policy in Europe. They are the ones to contact if you have questions related to repositories, to the scope of obligations and so forth. You can check the website, it's very, very comprehensive. In terms of dissemination, I already said, it's always important to first decide about the protection before actually taking the dissemination steps. In principle, according to the grant agreement and depending on what your consortium agreement says, you will have to inform the other partners in writing before you actually disseminate the work. In Horizon 2020, this notification delay was really long. It was 45 days. Now they have reduced it to 15, which is perhaps well, more flexible in Horizon Europe, but those can actually be changed in the consortium agreement. So always make sure you double check your consortium agreement to check, the time frame, to notify the partners, to let them object if they have an objection, and then to go forward with the publication. As I mentioned, open access is really now the general principle of scientific dissemination. And there's something that is new in Horizon Europe by comparison to Horizon 2020, is that in Horizon 2020 there was already the open access obligation, but it didn't come with any kind of compulsory licensing scheme. The obligation was just to put the work out there online in electronic format, accessible to all for free, and that was all. It didn't give the readers, so you would, as a researcher, you work in a repository. This didn't give the readers any right to reproduce your work, for example. This has changed in Horizon Europe, where now, along with the open access obligation, in principle, you have an obligation to release your work, especially articles, in CC BY licenses. So those are the rather open, permissive Creative Commons licenses. And this actually allows others to take up your work, reuse it as long as attribution is given. So by doing that, the Commission basically wants to ensure that the works can be further disseminated, while at the same time ensuring that attribution remains, so that you are credited for your work. I included a link here that's a little bit more information on this topic, with description of the various Creative Commons licenses that we wrote in our blog a while ago. And finally, don't forget to list all the dissemination activities in the dissemination and exploitation plan. I think we are reaching the end of this presentation. I just wanted to mention here something that could be of interest. This is not fully our scope, let's say, because it's about costs. So this is about financial issues. Sometimes people tell us, yeah, we would like to protect this and that, but it's too expensive. We don't have the budget, for example. Or yeah, we would need a, I don't know, a patent attorney or a lawyer right now, someone to draft us a proper IP exploitation strategy, but we don't have the budget. Remember that in principle, in Horizon projects in general, the cost of IP rights, including cost of protecting the results, royalties, attorney fees, etc., they are considered as eligible costs. So it's something to remember, so that perhaps you can actually plan this in advance already in the proposal. And if you have any questions on that, so on the eligibility of IP costs, this is not something where we at the help desk can help you in detail, because it's a financial issue, but there are specific support services that can tell you more. They are the legal and financial national contact points for Horizon Europe. So I would really suggest asking them if you have any doubts in this respect. I think we are reaching, we are a bit late now because it's 12, so I will actually pass the MSCA examples and FAQs, because first you will receive the slides, so you can actually read those examples. They are very comprehensive, and also because I already mentioned them as examples during the presentation. So for example, this one was a common question asked about the obligation to protect the results, and how this is not necessarily an obligation to patent. This was a common question about the partner organizations in MSCA and whether or not they should sign the grant agreement. The bottom line is that in principle it's better to involve them separately by way of partnership agreements, but sometimes if you prefer to have them in the consortium agreement, it's possible. But then you have to be really careful about the wording to make sure that you really distinguish which clauses applies to which category of partners. So it might be a little bit trickier. This is, the common case that I already mentioned about the fellow going for secondment, for example, in the US, and the partner organization having claims over the results developed while on secondment. As explained, this partner will not have actually, under the Horizon framework, this partner is a third party, so they won't have any automatic rights to the results. However, it is possible, and actually it is recommendable if this is the condition for them to agree to be involved. It's possible to actually negotiate those rights, to transfer half of the ownership, to give them a license. So it's possible to be flexible while remaining, compliant with the grant agreement. The common question received, this is again something that I tackled throughout the presentations. I will answer them in 1 second right now, just to summarize. Who owns the results generated during the secondment period? In principle, it will be the beneficiary sending the FLO, but if the secondment partner has some claims, it's possible to agree otherwise. It's possible to agree on shared ownership, for example. Can we reach an agreement transferring some of the results to the partner organization if they are located outside the EU? In principle, yes, but there are possible restrictions that may apply in your grant agreement with regard to international transfers of ownership. So you should check, and if these restrictions apply, you might have to notify the Commission first. So something to keep in mind, because then you will have to anticipate the issue a little bit more. Which IP clauses should we include in the consortium agreement? Here I recommended some models, especially Leroux, BAC, and the DESCA one for Horizon Europe. Question sent by the partner organizations. The common concern is whether basically as a partner organization you would have any rights over MSCA results. The answer is that automatically no, because the grant agreement does not contemplate that. However, it's something that you can absolutely negotiate. And if this is the condition for your involvement, then the beneficiaries concerned will have to find a way. And finally, questions from individual researchers. I'm preparing a proposal. What should I say in the IP management section? Here the answer is always, please go see your tech transfer or EU project or legal office, because you have to draft this with them in line with their own policy. And which rights as a researcher do I get over the results I generate during the action? Depends. In some countries like Sweden, probably you will get ownership. In most countries, you will not. So if you want to retain access rights or license or the right to use your results after the end of the project, it's possible, but it's something that you have to keep in mind, something that you have to negotiate. Well, sorry, this presentation took a little more time, but I think we still have a bit of time for questions. So I think I will give back the floor to Michele, and I would like to thank you very much for listening to the presentation.
Thank you very much to you, Leah, for the very clear presentation. There are indeed a few questions, and I think we can see them together. First question, for those of you who have connected a little later, the slides and the recording are going to be made available at the latest tomorrow morning. And then question 2, will there be a new Lero CA for DMs, and if so, when? I think you answered that already, that we actually don't have this information. But
Michele, sorry, can you share the question list, because I do not see it.
Strange. You should be able to see it.
Okay, no, now, sorry. I think it was an issue on my side. Now I see it.
Okay.
Yeah. So yeah, the new Lero, I don't know. In fact, if someone today here is actually part of this organization and knows anything, it would be, for us, it would be great to know. On our end, we don't know, unfortunately.
All right. Then a note that I just put it, that the M card has been updated to Horizon Europe, and I think you said it already.
No, actually, this one I didn't know. I didn't know it had been updated, so that's good to know. But it's not for MSCA specifically. That's true.
No, it's not. It's not. And where can the latest annotated model grant agreement be found? Is just the pre-draft from November 2021. Can we expect an updated and more completed version of that case? I think it's already available. We can put it in the follow-up email as well.
But I think it's still, I can check now, but I think it is still the one from a year ago, in fact. It is still a kind of draft form. It is, I mean, it is in the portal. So it's, let me check now. I'm on the portal already. Horizon Europe. It's the one that is guidance. I would say it's this one actually, the one you are mentioning. Yeah, it's the one. It's the pre-draft from 30 November. Fortunately, it's hard for us to know too because we are not part of the commission, so we are not the ones working on those documents. So we don't know if there will be like well, an updated and more complete version. Hopefully, yes, but we don't have information on the timeline, unfortunately.
Yeah. And let's go on. Do you consider that the background of associated partners is not needed for the implementation of the project or the exploitation of the results?
Well, it would really depend. The thing is, I cannot answer this question because it depends on your particular case and how you structured your project, whether you are bringing in an associated partner whose know-how is crucial to the project. In that case, actually, their background might be requested. What is certain is that associated partners are third parties. They are not beneficiaries. So because of this status, the grant agreement will not submit them automatically to access rights, rights and obligations. But if it turns out that in your specific project, associated partners, because of the way you structured your project, they actually have really relevant know-how, and this might be even the reason why you involve them, then it's very important to try to extend some access rights clauses to them as well to make sure that the project works correctly.
Can you give an example of non-commercial exploitation other than policy guidelines?
Well, to be honest, for me, non-commercial exploitation would be mostly used for further research. I don't know, Michele, if you have other ones.
No, I agree. I was thinking about further research as well. Policy guidelines is another very common use, educational, like in university.
True. Educational, or perhaps also simply making your work available, for example, under I don't know, an open license or something like that, for take-up for free or things like that.
Yeah. And could you something about exploitation in the form of open access publication that you just mentioned with the new requirement of Creative Commons license, which CC exactly do I need to use, or is that up to the beneficiary? There are huge differences between them and some are a little bit problematic. I think you talked about that at the end.
I talked about that at the end, and I actually gave you a link to an article I wrote in our blog to summarize, because there are quite a lot of requirements. The main one that the Commission recommends is CC-BY, so it's the one that basically just requires attribution, if I'm correct. However, for longer works, they actually allow you to use CC licenses that are a little bit more restrictive. Let's say you can have all the detail in in two places in the in this article that I mentioned. It's on the slide, so you will get the link this afternoon, and also in the Horizon program guide, where they have an entire table where they summarize the different CC licenses and what they recommend them for. Depending on the different types of outputs.
Yeah, the participants is adding that there are different subtypes of like CC-BY, but I think it's also cleared in the communication of the Commission.
Yeah. That's why. I mean, to be really honest with you, I don't know them by heart. I don't know the requirements by heart. So that's why I'm recommending that you check the resources that I said. In principle, now I'm checking the article I wrote that I recommend that summarizes everything. Actually, they recommend what I said, which is CC-BY 4.0. So it's really about sharing, adapting, commercial, non-commercial. There's just basically it's just about attribution and indicating if changes were made to the work. So this is extremely permissive, and this is the one that is recommended by the Commission. However, the Commission, what I mentioned already, what the Commission allows you to resort to more restrictive licenses in some cases where basically for longer works, so long text formats, monographs. And in these cases, so for long works, they say that you can use CC BY and C. So that actually prevents commercial uses from others. And CC BY and D, that basically it does not allow distribution of adapted versions, or you can actually mix them up still for long works and use CC BY and C and D. So non-commercial and no derivative work. So I would really encourage you to check the program guide and this article I mentioned. It's all summarized in there, but the main one for article is actually CC BY 4.0.
Right. Is there an available template for the plan for exploitation simulation and communication of project results? No, we have a template about that, but it's of a couple of years ago still. So we are going to update that definitely, but at the moment there isn't. In my grant agreement and the deadlines in the founding portal give as deliverable 3 communication, simulation, exploitation on month 24 as deliverable. So at the end of the MSCA PF, are you sure about month 6? Is that a mistake in my grant agreement?
No, I wouldn't say that it's a mistake in your grant agreement. I think you have to stick to what your grant agreement says. What I said in terms of the plan for exploitation dissemination of results is a general recommendation or general principle that something that the Commission published when they launched Horizon Europe, saying that in many cases they will require a full-fledged draft by month 6 or something, but this was a general guidance from the Commission. So it's really important that you stick to your grant agreement, and in that you can always ask your project officer to confirm the timeline of your deliverables. But I mean, I would say in principle, Michaela, I don't know what you think, but I would say in principle stick to your calendar, no?
Yes, definitely. That what you said is the general rule, what the rules say regarding the plan, and it could be that the deliverable is then the update of the plan eventually. So could you say again what ROL stands for?
Yeah, result ownership list. So that's this list. Question 11, I actually don't know, because actually I think I said both. Michaela, do you know? I could check that, but
it's not a deliverable. At least it is not if you don't specifically write that in the DOA as a deliverable, and it's part of the final technical report. You can decide to make it a deliverable eventually. That's up to you. Then question number 12, what happens the IP conditions set out in a hosting agreement between the beneficiary and the hosting institution? Can we share IP with the hosting institution, not beneficiary or not associated partner? Should it be clearly mentioned that the hosting institution cannot share the IP arising by the research doctor and fellow under the European project?
And that's what I mentioned several times. That's a common concern in MSCA. There is no rule here, which means you have to remember that if the hosting institution is a third party, for example, if it's an associated partner, it does not necessarily benefit from automatic rights to the results because it's considered as a third party. It doesn't mean that you have to cut them out of the results. It means that if they are interested in owning some results, this is something that you have to negotiate with them. So bottom line is that you can let them own some results, but they won't have this right automatically. But in many cases, they will actually ask this as a requirement for them to participate. So you have to be flexible.
Then question 13, do we have to ensure the exploitation of the project even after, or even in projects where we have no IP rights on the invention or on the results?
Yes, I mean the Commission doesn't say you have to exploit the IP rights. They say you have to exploit the results in general. And in many projects there will be few IP rights or no IP rights at all. So it's about exploiting the knowledge, making sure that the knowledge is put to use, even if there are no IP rights.
Yeah, and for example, in some cases, do not generate barriers for the exploitation. So that means follow the rules that Leah has given regarding access rights, for example, to certain information that might be necessary for the exploitation activities, even if you're not like directly owner. However, some of your info, some of your know-how could be needed. Therefore, even if you're not directly owner, you still play a role in the exploitation. Obligation to disseminate. In which time period after the funding period in MSCA does that need to be realized?
The Commission doesn't say. It's not like for exploitation obligation, the Commission says 4 years. For the dissemination obligation, they don't say anything. So they just say as quickly as possible. But there is no time frame. So you can consider that if you have, I don't know, if you have released a website, if you have taken part in conferences, perhaps published something, then you can consider that your results have been disseminated.
What can we do when our institution doesn't really have a legal department that helps us draft these documents? Or using the templates, the DESCA is enough to be sure that we are protected in terms of intellectual property?
Well, here I think it's our obligation to recommend, to always tell you that it's always recommended, if you can, to get those contracts reviewed by a lawyer. This is the way to, if you have general questions, of course, our helpline is here to help you. But as already mentioned by Michele, this is first-line support, so we cannot give you legal advice, legal opinions. For example, telling you, ensuring you are sufficiently protected is legal advice. So it's not something we can do for you. We cannot basically help you protect your interests. So the recommendation is to go check a lawyer. Of course, the templates are a good start because the templates are widely used, widely understood by the community, and they are also fully compliant with the grant agreement. But they're only templates, so it means you have to check them, to read them. DESCA has also annotations to help you understand the clauses, and you have to change whatever doesn't fit your needs. That's very important.
Also, the user was confirming that the results ownership list is only due at the end of the project. So, as we were saying,
it is due at the end of the project. However, I would still say that it's something that could be that it would be good practice to anticipate it and to work on it before, because this can lead to disagreements.
And then for MSCA SE call, is there any special requirement that should be noticed? For example, the cross-section exchange to a company, or maybe it's a little bit too detailed.
Yeah, I have to say I don't know because you would need to check the call and the work program and to see if there's any specific requirements in the work program. But in principle, no. MSCA staff exchange are the same rules as the ones in MSCA general. It's the same. And if you exchange to a company, you just have to make sure that it's clear for both parties who owns whatever output could be generated during this exchange. It's the same as in others.
Right. For the consortium agreement, is there any IP or budget limitation for other organization? I'm not sure, Young, I understand the question correctly.
Me neither. And also I would perhaps suggest asking for anything related to budgets. I would recommend asking financial NCPs, national contact points.
I basically don't understand whether there's a budget limitation to include other organization in order to write down the consortium agreement. If you would like to be a little bit more specific, please. Could you explain further on the rights over results for MSCA fellows after the end of the project? Can fellow ask for support on negotiating a contract with the previous employer, so the beneficiaries of the MSCA from the IP help desk?
Well, as mentioned already right now, and also by Michele, unfortunately, this is not a service that we provide, meaning that we cannot act here. What you're asking is that we act like your lawyer, that we sit in the negotiations with you and help you negotiate. This is not something that we can do because we're not allowed. This would be us wrongly, let's say, competing with legal professionals. So here you have to go check with a lawyer. However, what I can tell you is that, as already explained, as an MSCA fellow, you might not have automatic rights on your results. You have to check the IP policy of your institution and your employment contract. It's possible, unfortunately, that, well, in many cases, that actually your institution owns your results. In that case, if you are interested after the end of the project to keep working on your results with another institution for commercial reasons, spin-off, whatever, it's possible, but it means you will need to get the rights to your own work. So I know it sounds a bit counterintuitive, but it's very possible that that your institution owns your rights. So basically, it means that you have to, you can actually do that, but you have to approach them and negotiate. To negotiate something like this, unfortunately, we cannot sit in the negotiations with you and take your side. That's legal advice.
Thank you. The partnership agreement between the beneficiaries and the partner organization could be the template secondment agreement, which is included in the CA letter template. I think it is attachment 6 or 7.
Well, I have to say, honestly, I don't know the attachments or the templates by heart, so I don't remember. However, I think, yes, if I remember correctly, the secondment agreement is anyway the agreement between well, the sending institution and the receiving institution with regard to the fellow being sent on secondment. So that is the idea. However, check what is in there, because it might be necessary to add additional clauses, especially about IP. That's why I recommend the one from COVI, although it's old, from ITN 2015, because it's a good example. It's quite short, but it's a good example of a partnership agreement that tackles intellectual property. So it's something that you can use as an example and then build your own, add some clauses in another template, etc. But I think it's a good example and fully compatible with the grant agreement.
Thank you very much. Leah, also one last question, whether we are going to share our template from the European IP Help Desk on the plan for dissemination, communication, and exploitation. I will put it in the follow-up email from Miriam. And I think this is it. A very big thank you for the presentation and the clarity in the explanation to Leah.
Thank you, Michele, for always being like the big help in the presentation and the moderation. And thank you to everyone who took part in this event today. I hope that was, well, that helped you clear some doubts and learn a little bit more about IP and MSCA.
Thank you to everybody. And if you want and you have time tomorrow, we're going to double meet with the EPO at 9:30, and then again with Christian Hackel talking about freedom to operate at 11:30. So it's going to be a busy day. If you'd like, you can join. Yeah. Goodbye and have a nice day, everyone. Thanks a lot.
Have a nice day. Goodbye. Bye.